Welcome to the Analyst. Today we'll be taking up 9 newspaper articles from the Hindu and the Indian Express and discussing them. The handout for the same will be available in the description of this video for your kind perusal. Please have a look at that. The first article that we'll be taking up is related to left-wing extremism, as Maoists have suffered severe setbacks in Chhattisgarh in 2024. The second article is related to same-sex marriage, as Supreme Court is going to hear petitions seeking a review of the October 2023 judgment, whereby the Supreme Court had refused to legalize the same-sex marriage in India. The third article is related to SC/ST Prevention of Atrocities Act, as there are allegations of large-scale atrocities against SCs in Tamil Nadu. The fourth article is related to Digital Competition Bill, which proposes to bring in ex-ante competition regulation in India. The fifth article is related to High Seas Treaty, as India is going to soon sign and ratify the treaty. Additionally, we'll be taking up 4 prelim snippets. The first article is related to left-wing extremism. The context behind it is that the Maoists have suffered severe setbacks in Chhattisgarh in 2024. The number of Maoist deaths have gone up in 2024. The number of civilian casualties as well as the casualties suffered by the security forces have come down. So we'll discuss the topic of left-wing extremism, the nature of left-wing extremism, the dynamics of left-wing extremism, the reasons behind it, as well as a few government initiatives to tackle it. This is important in GS3 under the topic linkages between development and spread of extremism. So, where do left-wing extremists operate? They operate in areas where there is an absence of administrative institutions, where there is lack of governance, where the people are disenchanted. The people feel exploited and they get disgruntled and they get disenchanted, and therefore they become easy targets for the left-wing extremists. In India, they operate chiefly along the Red Corridor, along 10 states in India. And essentially they try to offer alternate systems of governance. Now, how did it come into being? The British created and legitimized jamidars. They wanted revenue collection from agriculture. Therefore, they created large jamidars, and therefore many people were left landless. Now, after independence, India tried to take up land reforms for the redistribution of land resources, but it did not succeed to the extent we wanted it to. There was manipulation of land records and various other issues. Now, also the state monopolized over the mineral and forest resources. There was crony capitalism also. We wanted development to happen and then it to be trickled down to the grassroots level. But the trickle down also did not happen. Therefore, the areas where there was mining, where there was exploitation of mineral resources, etc., again it led to disenchantment among the local population, among the local tribals, which again led to them joining the ranks of the left-wing extremists. Therefore, there was formation of tribal associations also. For example, in Jharkhand, there was Jharkhand Mukti Morcha, etc. It led to the boost to Maoism. And essentially, their purpose was to insurrect and armed insurgency against the government, to spread propaganda, and they wanted to show that the state had failed, to encourage people to join their ranks. Let's see a case study of Jharkhand, for example. How did left-wing extremism spread in Jharkhand? It has a positive correlation with mining. Wherever mining happened in Jharkhand, there was a spread of Maoism, left-wing extremism. For example, in Lohardaga, there was mining of bauxite. Now it has been exhausted. Likewise, in Pakur, coal mining started essentially from the 1990s onwards particularly. There was a simultaneous steep surge in Naxalism over there. So there is a positive correlation with mining. There were Cubs in Chhattisgarh in the neighboring region. Therefore, there was a massive influx of insurgents into Jharkhand, the influx of left-wing extremists into Jharkhand. The intensity is higher in the border regions because they try to take advantage of the lack of coordination between the law enforcement agencies. And if the law enforcement agency of one state is chasing them, they cross the border and enter into another state. The other state, they feel safe then. They try to establish parallel systems of governance. For example, Jan Adalats, they try to establish kangaroo courts, saying that if justice is denied, you come to us, we'll bring justice for you. They issue diktats. For example, they ask people to boycott polls, etc. Now, what are the reasons behind the left wing extremism? One are the land related reasons. For example, the D. Bandyopadhyay committee had also listed down the reasons behind left wing extremism in detail. Like, people evaded the land ceiling laws. The government tried to put a cap on the maximum amount of land that a person can hold, but there were transfers of the land to pseudo owners and the laws were evaded. There is encroachment and occupation of the land by the people who have muscle power. There is a lack of titling to the cultivated land. For example, pattas are supposed to be granted under the Forest Rights Act to the tribal people so that they are recognized as the owners, as the people who should have control over the forest land, but they are also not given. There is a poor implementation of the fifth schedule. It essentially is to ensure that the rights of the tribals are protected, the vulnerable sections, and there is a non-regularization of the traditional land rights under the Forest Rights Act also. Plus, there are reasons like displacement and forced evictions. For example, there were displacements wherever the government takes up a major project like Sardar Sarovar Dam. Then there were protests in the form of Narmada Bachao Andolan. Various activists also participated like Arundhati Roy, Medha Patkar, etc. And they argued for more compensation, better rehabilitation provisions from the side of the government. Then there is the lack of livelihood. Because the traditional land, which is the major resource for the tribals, if it is snatched away from them, they are facing issues of food security. There is a disruption in the traditional occupation, and under FRA also they do not get the land rights or issued pattas, therefore it leads to livelihood issues. Then there is the issue of social exclusion, that the dignity of the tribals that is affected. There are issues like untouchability and even the implementation of the statutory safeguards which is not up to the mark. There are governance related reasons also. For example, the last mile delivery, the last mile governance in such areas is missing, and hence in the absence of the public services which is supposed to be from the side of the government, the people turn to the left wing extremists also, and the power also is misused in such reasons, which is acting as a motivation for the left wing extremists to encourage people to join their ranks. The attached chart although shows that the number of Maoist deaths in 2024 have increased. Likewise, the deaths of civilians has decreased and the death of security forces has also decreased in 2024. Now, what is the nature of left wing extremism? One, it is largely agrarian in nature. They make those people as their victims, make those people join their ranks who are the marginalized people and who are engaged in agriculture or who are forest land dwellers. They seek to mobilize the discontent among them and say that there is misgovernance, particularly in the rural areas, and attract people. They create even conditions for the non-functioning of the government. For example, they mobilize the marginalized, and the people who are not marginalized, they create fear among the law-abiding citizens, and thus they disrupt the developmental work also. Now, what is the dynamics behind it? One, the central theme of the left-wing extremists remains violence. They rely on violence to create an atmosphere of fear, and they even resort to armed insurgency to overthrow the systems of governance there. They resort to guerrilla warfare in the lower levels of government. They kill the local Panchayati Raj officials, the lower level officials at the grassroots level, the party workers, etc., saying that we are annihilating the class enemy, which is again their propaganda. They go ahead and recruit people even from the urban educated class also through propaganda. Some of them are coerced to join their ranks, and some of them are encouraged to join because they get radicalized through the disinformation campaigns that Maoists resort to. There are even frontal organizations also that are set up by the left-wing extremists. For example, they take up issues like tribal displacement. They say that the tribals are displaced and their land is taken away by the corporates and there is corporate exploitation, then there is also simultaneous human rights violation by the forces who try to implement the government directives. They try to use the state structure also to further the Maoist agenda. Thus, they provide a kind of a platform to cover up the oppressive Maoist ideology, and in the long run, they encourage people to join their ranks both through persuasion as well as coercion. Let's look at some data also regarding the left-wing extremism and its spread in India. In the decade from 2010 to 2021, it has actually come down. There have been a 77% reduction in the incidents of Naxal violence in India. The number of deaths, both civilian as well as security forces, have come down by 85% in the decade from 2010 to 2021. The geographical spread of violence has also been reduced from 96 districts to only 46 districts. In 2021 alone, 90% of the total deaths of security personnel happened in Chhattisgarh. That is 45 out of the total 50 deaths among the security personnel. The remaining 5 happened in Jharkhand. The most left-wing extremism affected districts in India have come down to only 25 in 2021. As per the BPRD data from 2018 to 2022, there has been a reduction. So we can say that left-wing extremism is reaching its final phases because there is a reduction of 39% in terms of the number of incidents related to left-wing extremism, 26% in security forces casualties, 44% in civilian casualties. This data is from 2018 to 2022, and 24% reduction in the number of districts affected by left-wing extremism, bringing it down to 39 only. So it has been a big achievement. Now, what are some of the government interventions in this regard to curb this menace? Let's look at some case studies. First, how the government has experimented on the grassroots level to tackle left-wing extremism. One, we came up with Salva Judam. Salva Judam is a practice whereby the local tribal people, they were given arms. They were designated as special police officers. But this led to the violation of human rights also. And even the Supreme Court declared that this practice of Salva Judam, designating some tribals as special police officers, giving them arms, is null and void. So this practice was done away with. Then there was the experiment of Andhra Pradesh Greyhound model. This model is based upon surrender and rehabilitation. So essentially it is about giving another chance to the left-wing extremists to start again. And here there was coordination among the security forces also to make sure that they are persuaded to give up arms and join the mainstream. There is the Naga Mothers Association. The government negotiated with this association to ensure that there is a reduction in the drugs related incidents and extremism in Nagaland and in the Northeast in general. This was also a positive experiment. Then there was the setting up of district reserve groups in Chhattisgarh. These groups were set up by taking people from the local area only. They were locally trained and they were raised to fight, engage in guerrilla warfare also, because they were well versed with the terrain, and it was also a reasonable experiment. Then the government came up with the Samadhan doctrine, which is again a comprehensive doctrine to deal with left-wing extremism. As police and public order, they are state subjects under the constitution. Therefore, the center also provides the resources to the states to help them tackle this menace. For example, it provides central armed police forces, the IR battalions, the counterinsurgency and anti-terrorism schools are set up by the government for encouraging training, modernization, sharing of intelligence among the law enforcement agencies, promoting coordination among different state agencies and law enforcement agencies. It provides assistance in community policing as well as various civic action programs. The government also came up with an umbrella scheme, modernization of police forces. Under this scheme, there are various schemes. For example, the security related expenditure scheme. This is to reimburse that expenditure which is taken up by the state governments on the modernization of police forces and their training, etc. This is reimbursed by the central government. Then there is a special central assistance. This is to fill in the gaps in the public infrastructure, particularly in the left-wing extremist infested areas. There is a special infrastructure scheme. This is to provide funds to promote infrastructure in such areas. There is the civic action program. The civic action program is to show the human face of the security forces, to promote interaction among the people and the security forces, to ensure that the people trust the security forces. There is the media plan. It is to ensure that there are ideas exchange. There is the tribal youth exchange program to ensure that the tribal youth, they cannot be radicalized, they cannot be misguided. There are infrastructural initiatives also, because left-wing extremism is not only a law and order problem, it has to be looked at like a holistic issue to ensure that people are not disenchanted due to lack of development. Therefore, the government started the Road Requirement Plan 1 road connectivity project, both to improve connectivity, and the left-wing extremist areas mobile tower project to ensure that there are lines of communication. And through the aspirational districts program, the government focuses specially on such districts where there is lack of development. Now, this is a sample means question that you can try writing. Discuss the nature and dynamics of left-wing extremism in India and evaluate the effectiveness of government interventions to counter this threat. The next article is related to same-sex marriage. The context behind it is that the Supreme Court will hear petitions seeking a review of an October 2023 judgment. In October 2023, the Supreme Court had refused to legalize the same-sex marriage in India, saying that it lies within the legislative domain. It is up to the government to do so. This is important in GS2 under the topic governance. Now, what did the Supreme Court say in the October 2023 judgment? This was a 5-judge bench judgment, whereby there was a majority judgment of 3 judges and there was a minority judgment of 2 judges. Both of them concurred that the same-sex marriage in India should not be legalized. There were other issues also which were discussed. For example, whether the right to marry in India should be termed as a fundamental right. Both the majority as well as the minority judgment concurred that the right to marry should not be termed as a fundamental right, because marriage is very important for an individual, but it is not essential for the very existence. Although the people should have the right to choose their partners, because it is in line with the Article 21 also, the right to life and personal liberty, which should not be snatched away without due process of law. The demand to modify the Special Marriage Act to ensure the legalization of the same-sex marriage was also not met by the judgment of October 2023, because there the court again observed that this again lies within the domain of the legislature, and this modification, if needed, it will be a matter of public policy. The court also recognized that the transgender persons, they do have a right to marry. Although in the judgment the court had concurred that we may allow a civil union. Civil union is like a halfway approach. It is not about legalizing the same-sex marriage, but allowing legally a civil union between two people. The minority judgment had said that it can recommend the government to set up a committee to encourage civil union in India to permit it. But again, the majority judgment had said that the civil union, again, it is a matter of public policy. If the government wants to do so, it has to be done through the legislature. Regarding the right to adopt, the minority judgment had said that the Central Adoption Resource Agency, its rules are not based upon the right to equality and they can be modified. But the majority judgment there also had said that adoption may be allowed, but again it has to be done by the legislature only, and judiciary will not be stepping into this domain as well. Now, what are the arguments in favor of the legalization of same-sex marriage in India? One, the petitions say that if same-sex marriage in India is not legalized, it will lead to the violation of Articles 14 and 15 of the Indian Constitution. Article 14 provides for the right to equality, and Article 15 says there can't be any discrimination on the basis of sex. And as per the Navtej Singh Johar judgment also, the Supreme Court had observed that people have their freedom of sexual orientation, and this sexual orientation is included in the term sex, which is mentioned under Article 15, that there should not be any discrimination on the basis of sex. This was observed while decriminalizing Section 377 also. Now, this is in line with the progressive realization of rights in the society. As the constitution also is transformed, as there is a wider interpretation of the fundamental rights, this is also in line with it. Because, for example, even Article 21's interpretation has been widened over a period of time. Like through Menka Gandhi case, its interpretation was changed from a literal interpretation to a liberal interpretation. The lack of legalization of same-sex marriage may violate the right to privacy also, because if they do not have the right over their autonomy, over their bodily choice, then it will lead to the infringement of right to privacy, as per the Puttaswamy judgment also, whereby it was observed that the right to privacy is intrinsically a part of life and liberty under Article 21, and hence it is a fundamental right. Plus, the same-sex couples, they will get legal protection if their marriage is legalized. They will get rights to adopt a child. They will have benefits of surrogacy, inheritance. They will be able to own land, etc. Because, for example, surrogacy in India is also not allowed for unmarried people. For this, you have to be married. The same-sex marriage is also considered as part of human rights. Otherwise, there will be human right violations. These are the arguments in the petitions. Even the Universal Declaration of Human Rights under 1948, the right to marry was considered as a human right, and the United Nations also encourages the legalization of the same-sex marriage as it is considered as a human right. Plus, they will get a social acceptance. The same-sex couples, they face stigma in the society. They face discrimination in the society as long as their marriage is not recognized by law. Plus, it is not true that only a few urban people, only a few elite people want it to be legalized. It is said that about 7 to 8% population in India support homosexuality and demand for the legalization of the same-sex marriage in India. Plus, the global acceptance of this has also increased. Currently, more than 33 countries across the world have legalized the same-sex marriages. Now, what are the arguments against the same-sex marriage? Its legalization, one, it will lead to the legal issues. The personal laws related to adoption, inheritance, etc., they will have to be revised along with the modifications in the Special Marriage Act, whereby it is demanded that the terms man and woman can be replaced with the terms spouses to ensure that the same-sex couples can also get married. There will be legal issues and hence requiring the amendment in the statutes. Plus, it is a matter of public policy. It should be the legislature, it should be the government to take this decision rather than the judiciary imposing its own morality upon the society. The child rights may be affected because the children of the same-sex couples, again, they may face reverse discrimination, they may face stigma also in the society, because the religious and cultural beliefs in India, they do not allow for the same-sex marriages as openly. It will lead to the disruption of social norms also, because some of the norms, set societal expectations may be violated. Plus, it may be going against the laws of the nature. It is said that the primary purpose of marriage is procreation, and which may not be biologically possible for the same-sex couples, and hence it violates the laws of nature. It is even said to be the demand of just a few urban elite people as well. Now, the next article is related to SC/ST Prevention of Atrocities Act. The context behind it is that there are allegations of large-scale atrocities against the SCs in Tamil Nadu. So, we will discuss the evolution and the provisions of the SC/ST Prevention of Atrocities Act. This is important in GS2 under the topic Mechanism, Laws, Institutions and Bodies constituted for the protection and betterment of vulnerable sections. It's a nice quote by Gandhiji. Our struggle does not end as long as there is a single human being considered untouchable on account of his birth. So, how did this act come into being? Article 17 under the Constitution provides for the abolition of untouchability. In line with this, the government enacted the Untouchability Offences Act 1955. Subsequently, there was the Protection of the Civil Rights Act of 1976 also. But due to the ineffectiveness of these acts, the government came up with the Act of 1989, Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act. Now, what are the provisions of this act first? It prescribes for 37 offences. If any person commits these offences against a person belonging to a scheduled caste or a scheduled tribe, then it will attract penal provisions. These offences contain the patterns or behaviors which inflict criminal offences or which are breaking the self-respect, esteem of scheduled caste and tribes, or which result in the denial of economic, democratic and social rights, which lead to discrimination, exploitation or abuse of the legal process, and ultimately they are discriminatory against the scheduled castes and scheduled tribes. All of these offences are cognizable. The investigation for these offences can be conducted by a police officer of the rank of DSP and above. The investigation has to be completed within 30 days. The Act under Section 18 also provides that no anticipatory bail is allowed if a person commits an offence under the SC/ST Prevention of Atrocities Act. For any other offences under IPC, usually an anticipatory bail can be sought from the court under Section 438 of CRPC. Now, this is not applicable for the SC/ST Act. Under Section 4, it prescribes that the public servants who are neglecting their duties under this Act deliberately, they are also punishable. Special courts can be set up by the states. These special courts will be set up in the districts by the states in concurrence with the Chief Justice of the High Court of that state. Now, the provisions, they have evolved over a period of time. Under the 2015 amendment, the Parliament said that there should be more instances of atrocities added as crimes against the SCs and STs. That special courts should be established by the states and special public prosecutors should be hired. The term willful negligence by the public servant in case of dereliction of duty under this Act was defined, and it was defined ranging from the registration of complaint, registration of FIR under this Act to dereliction of duty under this. And it provided that if the accused is acquainted with the victim, if the person who committed the offence under the SC/ST Prevention of Atrocities Act is known to the victim, then the court shall presume that the offender was aware of the caste identity, of the tribal identity of the victim, and hence he is punishable. In the Kashinath Mahajan case, the Supreme Court provided for certain safeguards to prevent misuse of the SC/ST Prevention of Atrocities Act. The court said that advance bail can also be given, although anticipatory bail is not allowed under the SC/ST Prevention of Atrocities Act, but the court said that advance bail can be given if there is no merit in a complaint under this Act. It also said that the preliminary inquiry should be conducted before the registration of FIR under this Act. And it provided for certain safeguards regarding the arrest also, that a person who has committed an offence under this Act can be arrested only after the approval of the SP level police officer, Superintendent of Police, or if a public servant is to be arrested, then the approving authority has to be at the level of the appointing authority. But in 2018, after a public outcry, the government again amended the SC/ST Prevention of Atrocities Act and it inserted Section 18A under the Act. Under the Section 18A, it was provided that the advance bail or anticipatory bail cannot be provided if an offence is committed under this act. The preliminary inquiry is not needed to be conducted for the registration of FIR under this act, and the arrests also do not require prior approval if a public servant is sought to be arrested under this act. So essentially, through the 2018 amendment, the government nullified the Kashinath Mahajan judgment of the Supreme Court. Now this was appealed again through the Prithviraj Chauhan case in the Supreme Court, where the court observed that the section 18A, which was inserted in the act through the amendment of 2018, it is constitutionally valid, although the court said that pre-arrest bail can be given in case an offence is committed under the SC/ST Prevention of Atrocities Act, but it can be given only where there are extraordinary situations or where the denial of bail will lead to a miscarriage of justice. Hence, the anticipatory bail can also be given, but it can be given only in exceptional cases, and the courts are not supposed to give anticipatory bail. Now, the next article is related to Digital Competition Bill. The context behind it is that the draft bill encourages an ex ante competition regulation in India, whereas the Competition Act of 2002, it provided for an ex post regulation of competition in India. This is important in GS2 under the topic governance. Now, how did this bill come into picture? In 2022, the Jan Sinha led standing committee had suggested that we need a digital competition law. Therefore, in February 2023, the Ministry of Corporate Affairs formed a panel. This panel was formed to look into the ex ante regulations which is required now for the big tech industry. For example, it is done in Europe in the form of Digital Markets Act to regulate the big tech including Google, Facebook, Amazon, etc. The stakeholder consultations were also done for the same in 2023, and a draft bill was prepared by the Ministry of Corporate Affairs to suggest the ex ante regulations for digital markets. Now, this bill proposes identifying systemically important digital intermediaries to ensure a competitive ecosystem. What is the significance of this bill? One, it is to ensure that there is a level playing field. There is fair competition in the digital space. If there is no such regulation, then what will happen is that the big tech companies, they will favor their own services, or they will collect data from one business of theirs and help another one of their businesses. For example, Google search collects a lot of data regarding the user preferences. Now they can use it to give video recommendations on YouTube. They can use it to sell this to third-party advertisement companies who are dependent upon giving ads, who are dependent upon showing you ads. Now, the earlier framework was the ex post framework through the Competition Act 2002. This ex ante framework prescribes for the presumptive norms to curb anti-competitive practices even before they actually take place. So what does the bill provide for? It says that there should be a list of the core digital services. These services are listed under Schedule 1 of the draft bill. These services may include online search engines, for example, Google, Bing, Yahoo, etc. And it may be social networking services, video sharing platforms, interpersonal communication services, operating systems, web browsers, cloud services, advertising services, even online intermediation services like web hosting, payment services, auction sites, app stores, e-commerce marketplace. These are considered as the core digital services. It says that there should be some systemically significant digital enterprises. Some digital enterprises should be recognized as significant. How do you do that? By recognizing that they provide core digital services in India, they have a significant presence in India, and they have a significant financial strength. They have the money power to sway people's choices or to sway online platforms in India. What are the parameters for an enterprise to be termed as systemically significant digital enterprise in India? The bill provides for two tests. One is the financial strength test, another is the spread test. How much financial strength does it have? how many users does it command on its platform. The quantitative parameters are also prescribed that in the last 3 financial years, if the turnover in India for the digital enterprise is more than 4,000 crore, or globally it has a turnover of more than $30 billion, then it will be termed as a systemically significant digital enterprise. Or if the global merchandise value in India is more than 16,000 crores, or the global market capitalization of the enterprise is more than $75 billion, or the core digital service is provided to more than 1 crore end users or 10,000 business users. Also, an enterprise can be termed as systemically significant digital enterprise if the Competition Commission of India believes that it has a significant presence in any given core digital services. Now, it will have certain obligations. They will be imposed upon the significant digital enterprises. If they do not fulfill these obligations, there will be a fine which can be up to 10% of the turnover of the enterprise. The obligations include that they will not engage in any self-preferences. That is, if they are collecting any data, they should not use that data to promote their other entities or misuse it, or they should not restrict the third-party applications from operating through their platform and promote their own applications. Also, there will be an identification of the associate digital enterprises. The associate digital enterprises will also have the same obligations as the mother enterprise or the systemically significant digital enterprise. How do you determine whether they will be termed as associate or not? Depending on the level of their involvement with the core digital service. For example, Google Maps. The Google search, if you search for the directions to any place, the Google search itself directs you to Google Maps. So it can be termed as the associate enterprise. Hence, it is involved in it through the core digital service. Now, what are the criticisms for this bill? One, it may lead to enhanced compliance burden. That the ex ante framework, it has strict prescriptive norms, and there might be a shift of focus from innovation and research to ensuring that there is no presumptive engagement. We are trying to make sure that there is no engagement in any anti-competitive practice. It may stifle innovative products through the online channels. The stringent requirements of the European Union's Digital Market Act had an adverse impact. Now, similar requirements are put in place in the Indian bill also. What impact it had in Europe? There was an increase of 4,000% in the time to find things via Google search, because the anti-competitive practices were put in place, and the definition of the significant platform, that the systemically significant digital enterprise, it has been left to the discretion of the Competition Commission of India. Only the broad parameters have been mentioned. Whereas in the case of European Union's Digital Market Act, the act itself has specifically named the gatekeeper entities, the major ones like Facebook, Google, Amazon, etc. And the bill may also affect the smaller businesses, as it may force them to make the changes to their platform and cut down on data sharing, because these smaller businesses, they depend on such digital enterprises only to expand their outreach. So who is supporting the digital competition bill? There are some entities who are supporting also. For example, Paytm has supported the framework only if large digital companies are subject to it. Make My Trip also favors it, provided it is for the select large horizontal platforms only, and certain trade bodies also support it. But there are certain entities who are against it, particularly the smaller or the newer entities or the startups. Like Zomato had said that the framework should not stifle innovation in the startups. Likewise, Swiggy has also objected to it. Now, the next article is related to the High Seas Treaty. The context behind it is that India will soon sign and ratify the High Seas Treaty. This is important in GS2 under the topic bilateral, regional and global groupings and agreements involving or affecting India's interests. What are high seas? The waters up to 12 nautical miles from the baseline of a country in the sea are termed as territorial waters. Another 12 nautical miles are termed as the contiguous zone. Then there is the exclusive economic zone from 12 nautical miles from the baseline to 200 nautical miles from the baseline. The waters beyond the exclusive economic zone are termed as the high seas. That is, high seas start from 200 nautical miles from the baseline of the country, and after that it is the high seas. They are under the jurisdiction of no country. All countries in the high seas have a right to fish, right to ship, and even right to do research. And more than 60% of the world's oceans by surface area are part of the high seas only. Now, in the high seas, activities are often unregulated and often they are insufficiently monitored, and hence they are vulnerable to exploitation. Therefore, there was the Paris Agreement for the ocean which came into picture. Then the High Seas Treaty. This has been built on the legacy of the UN clause. Now, what are the provisions under the High Seas Treaty? The High Seas Treaty seeks to place 30% of the seas into the protected areas by 2030. This is part of a pledge under the UN Biodiversity Conference also. And it seeks to put in place a legal framework for the establishment of marine protected areas. Through the marine protected areas, we'll be ensuring that there is less loss of wildlife biodiversity and there is sharing of the genetic resources among the countries. It also provides that there should be environmental assessments. The assessments to assess the potential damage that commercial activities may cause. For example, deep sea mining, how much environmental damage does it cause? It puts in place various mechanisms like polluter pays principle. It also puts in place the mechanisms for the dispute resolution under the treaty itself. Hence, it works like a guidance framework. It is providing for an integrated approach to ocean management, to build ecosystem resilience, to tackle the issues of oceanic acidification, to assess the impact of climate change, etc. It is also to recognize the rights and the traditional knowledge of the indigenous people, the local communities, and it promotes the freedom of scientific research. It also recognizes that there is a need for the free and equitable sharing of the benefits of the resources from the high seas. It even recognizes the special circumstances which the small islands are facing, because they are facing a disproportionate impact of oceanic acidification as well as the climate change and the rise in sea levels. It also recognizes the circumstances which are faced by the landlocked developing nations. Hence, it seeks to establish a conference of parties. This conference of parties will be a mechanism to make sure that the member states who choose to sign and ratify the High Seas Treaty, they will be made accountable on the parameters of governance, on the parameter of the biodiversity conservation and protection. Hence, it seeks to put in place a pledge by the signatories to share the genetic resources, to share the oceanic resources, etc. Now, we'll be discussing 4 prelim snippets related to the Safe Harbor Clause, the 6 for Justice Foundation, the Order of St. Andrews, and Florida Carpenter Ants. Now, the next article is related to the Safe Harbor Clause. The Safe Harbor Clause provides that an intermediary shall not be liable for the content which is hosted on its site and which is generated by a third party. It says that it shall not be liable for any third party information, data, or communication link which is made available or hosted on its platform. That is, if you share some content on Facebook, then Facebook shall not be liable for it if it is objectionable or illegal. It is applicable if the content, it is not initiated by the intermediary, there is no initiation of transmission by the intermediary, there is no selection of receiver, that is, the audience is not selected by the intermediary, and also there is no modification of the information by the intermediary. It must adhere to the intermediary guidelines and digital media ethics code to enjoy the safe harbor provision. That is, it has to appoint a grievance redressal officer. It has to appoint a chief compliance officer as well as a nodal contact person. Under Rule 7 of the IT Rules 2021, if the rules under the intermediary guidelines are not adhered to by the intermediary, then the safe harbor protection shall not be available for that. This is analogous to the Section 230 of the US Communications Decency Act. The US Act provides that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Essentially, it is also providing a safe harbor for the intermediaries. Now, where it is not applicable, it is provided under Section 79, Subclause 3 of the IT Act. It lays down the conditions for the intermediary to claim safe harbor protection, to claim safety from liability for any third-party content. Under subclause B, it says that the protection shall not be available if the intermediary fails to remove access or disable access or remove content from its platform after it has been notified by the government or its agency. That is, if the government notifies the intermediary that some content is objectionable, you have to remove it. If it is not removed, then it shall be liable and the safe harbor protection shall not be available to the intermediary. Now, the next article is related to 6 for Justice Foundation. This was established in 2007. The ostensible aim of the foundation is to ensure self-determination for the Sikh people in their historic homeland. Essentially, they demand a separate sovereign state. Overtly, they say that there is a wanton use of violence which we do not want to engage in. They even say that our motto is ballots, not bullets. They want to conduct a referendum. But again, it's a farce. For example, the Center for Referendum that it insurrected in Canada, that is named as Shahid Talvinder Singh Parmar Voter Center, who was actually a mastermind behind the Air India bombing of 1985. Likewise, this referendum of 2020, which was conducted among the Sikh diaspora, that's also a farce, because the rules for identification of the people voting for it, they were not clear, they were ambiguous. Then the statements and the threats they make, they usually threaten the non-Sikh diaspora. They indulge in violence, for example, the Air India attack. They espouse secessionism, espouse militant ideology, and they even defy terrorists. Hence, there are a lot of sedition cases also pending against it. The next article is related to the Order of Saint Andrew. This is Russia's highest civilian honor. Prime Minister Modi was awarded this honor for providing exceptional services in promoting special and privileged strategic partnership between Russia and India and promoting friendly relations between the people of India and Russia. Usually, the order is given to the prominent government and public figures, military leaders, and outstanding representatives of science, art, and economy for providing exceptional services to Russia. It can be provided also to the heads of foreign states for providing exceptional services. Saint Andrew was one of the apostles or the 12 original followers of Jesus. After the crucifixion of Jesus, the 12 original followers, they spread out and traveled far to spread the message of Jesus. The next article is related to Florida carpenter ants. These ants perform amputations on their injured nest mates as a form of wound treatment. They perform amputations if the legs of one of their mates is hurt. It is performed usually only on certain leg injuries. It suggests methodical and targeted surgical practices, and they significantly improve the survival rates. After such amputations, up to 90% of the ants actually survive. And it is observed from their behavior that it is consensual in nature, and thus it provides an insight into the ant social dynamics and medical behavior. This is how the ant looks like. Thank you.